Appeal the Queen against Mitchell.
Lord Kerr will explain the decision of the court.
On the 20th of October 2010, after a trial before a judge and jury at Belfast Crown Court, Angeline Mitchell was convicted of the murder on the 11th of May 2009 of Anthony Robin. At the trial, she didn't dispute that she had stabbed Mr. Robin, but she said that she'd acted in self-defense. She also claimed that she had been provoked and that she did not have the intention to kill Mr. Robin or to cause him really serious harm. During the trial, without any objection from the defence, the prosecution led evidence of Ms. Mitchell's previous bad character. And the purpose of that was to show that she had a propensity to use knives in order to threaten and attack others. The evidence related to two incidents, one in 2003 and the other in 2007. And in the course of those incidents, she was said to have threatened and indeed stabbed others with knives. But none of those incidents had led to a prosecution, and she had therefore not been convicted of any offence in relation to them. On her trial for the murder of Mr. Robin, the judge directed the jury to take the bad character evidence, that's the evidence that she had a propensity to act in a way that the prosecution claimed she had acted on this occasion, that he directed the jury that they take that bad character evidence into account or leave it out of account as they considered appropriate. But he went on to say they should not make any assumptions based on the bad character evidence as to Ms. Mitchell's guilt. She was convicted and she was sentenced to life imprisonment. More than 3 years later, she applied for leave to appeal out of time. Permission to appeal was given on one ground only, and that ground was that the trial judge had failed to direct the jury properly on the purpose of the bad character evidence or the standard of proof to which the jury had to be satisfied before that evidence could be taken into account. The Court of Appeal in Northern Ireland allowed her appeal and they quashed her conviction for murder. She was tried again in April 2016. On that occasion, she was acquitted of murder on the ground of her diminished responsibility, a defence which had not been raised in the original trial. She was sentenced to 10 years imprisonment for manslaughter, an offence to which she had pleaded guilty. Now, the prosecution appealed to this court on what was essentially a theoretical, but nevertheless an extremely important point. And the principal issue in the case related to the question of what direction a judge should give to a jury about bad character evidence where there had not been a conviction based on that evidence. The prosecution said that it didn't call for any special examination by the jury. By contrast, those who appeared for Ms. Mitchell argued that any facts supporting a claim that a defendant had a particular propensity had to be proved beyond reasonable doubt. This court has unanimously dismissed the prosecution's appeal. The court recognizes, however, that there is a distinction between, on the one hand, proof of a propensity, and on the other, proof of the underlying facts said to establish that a propensity exists. In a case in which several incidents are relied on by the prosecution to show a propensity on the part of the defendant, it is not necessary to prove beyond reasonable doubt that each incident happened in precisely the way that it is alleged to have occurred. Nor must the facts of each individual incident be considered by the jury in isolation from each other. The proper issue for the jury in a case such as this is whether they are sure, beyond reasonable doubt, that the propensity has been proved. The jury is entitled to, and indeed it should, consider the evidence about propensity in the round. That's because the improbability of a number of similar incidents being false is a consideration for the jury. And secondly, because obvious similarities in various incidents may constitute mutual corroboration for those incidents. Ultimately, however, the existence of propensity has to be proved to the criminal standard. That doesn't require that each individual item of evidence said to show propensity must be proved beyond reasonable doubt. And insofar as the Court of Appeal in the present case suggested that each incident claimed by the prosecution to show a propensity on the part of the defendant required to be proved to the criminal standard, that was wrong. The proper question is whether the jury is satisfied that a propensity has been established. And that assessment depends on an overall consideration of the evidence available, not upon a segregated examination of each item of evidence in order to decide whether it has been proved beyond reasonable doubt. We have taken the opportunity to emphasize that propensity, of course, is at most an incidental issue, and we consider that it should be made clear to the jury that the most important evidence is that which bears directly on the guilt or innocence of the accused person. Propensity alone cannot establish guilt.